Hi guys, and welcome back to my channel. Thank you very much, for supporting our YouTube channel, ladies and gentlemen. Maraming salamat po sa inyong walang sawang panunood ng aming videos, okay, na aming pong ina-upload sa aming YouTube channel that we call it Jamming Private Ryan. Alright, so pasensya na po kayo guys, medyo masama po pakiramdam natin ngayon kasi tinamaan tayo ng trangkaso. Masama kasi yung panahon last week. Actually, doon nga sa work, medyo matamlay tayo. So, hopefully, God's willing, matutulungan tayo na gumaling kaagad at tayo makabalik sa ating work in a very, very active and very, shall we say, productive sa ating pagbibigay serbisyo sa ating mga estudyante. Ayan. Alright guys, and for today's video, we are going to share to you a topic. Under pa rin po ito sa ating subject, Introduction to Criminology 101, guys. Ayan. At shout out po sa aking mga former first year students muna, Section D. Kasi karamihan po sa mga information na ating i-share dito sa ating videos ngayon ay galing po sa mga reports nila nung sila ay under sa akin noong first year pa po sila. So thank you so much sa ating mga estudyante dyan at pagbutihin nyo, ha. Sana pag after your graduation and you're going to take the board exam, take one lang pasado at para maligaya tayo lahat, especially yung mga parents nyo. Ayan, wala na po tayong ibang adhikain kundi pasayahin yung ating mga parents sa pamamagitan ng pag-aaral ng mabuti at ipapasa or papasahin yung criminology licensure exam. Ayan po. So, sige, wag na tayong magpatumpik-tumpik pa. So, yan, bago ang lahat, prepare nyo muna yung inyong mga snacks. Ako, prepare na po ako ng coffee ko habang ako ay nag-edit ng video na ito. Yan. At ito, yung snacks ko. Becky naman. Magic Flakes Cream. Ayan. Yan po yung mga snacks natin kasi medyo masama pakiramdam natin. So tayo po ay chumichikchak ng konti ng snacks at kape para medyo matulungan tayo sa ating paggagawa ng video or pag-edit ng video na ito. Alright, so we do hope that you're going to enjoy this video and we pray that you will learn something from this episode. Ayan po. So, sige. After this video, magbibigay tayo ng mga multiple type of question, multiple choice pala, sorry. Multiple choice type of a question. Tapos, pagpraktisan nyo. Ayan. So, thank you very much for watching and we're going to end this introduction right now so that we will going to go to the main part of this video. Okay, enjoy watching and pleasant day everyone. Bye bye.
Good day to each and everyone. We are the group 1 and we will discuss chapter 2, which is the essentials of criminal law. So without further ado, let's get into the video. Law refers to the body of official rules and regulations generally found in constitutions, legislation, judicial opinions, and the like that is used to govern a society and to control the behavior of its members. The nature and functions of law are diverse throughout history. In modern civilization, some authorized bodies such as a legislature or a courts enacts the law. It is supported by the coercive power of the state, which enforces the law by means of appropriate penalties or remedies. Formal lawful rules and actions are usually distinguished from other means of social control and guidelines for behavior such as mores, morality, public opinion, and custom or tradition. Law serves an assortment of functions. Laws against crime, generally referred to as criminal law, facilitate to maintain a peaceful, orderly, and relatively stable society. Law has also been used as an instrument for social change. At various times, laws have been passed to inhibit social discrimination and to improve the quality of individual life in matters of shelter, health, education, and welfare. Experts believe the popular idea of law overemphasizes its coercive and formal characteristics. They argue that if a custom or norm is assured of legal backing, it is for practical purposes law. On the other hand, a law that is neither obeyed nor enforced is an empty statute. Social attitudes toward the formal law are a significant part of the law in process. The role of law in China and Japan is to some extent different from its role in Western nations. Respect for the processes of law is minimal, at least outside matters of business and industry. Tradition comes out much larger in everyday life. Resort to legal resolution of a dispute is truly a last remedy, with conciliation being the mechanism that is ideal for social control.
Law is not entirely a matter of human enactment. It also includes the natural law. The best-known version of this view, the God's law is supreme, has had considerable influence in Western societies. The civil rights movement was at least partially inspired by the belief in natural law. Such a belief seems embedded in the view. The law should serve to promote human dignity, as for instance, by the enforcement of equal rights for all. Muslim societies also embrace a form of natural law, which is closely linked to the religion of Islam.
Law develops as civilization progresses. The simplest societies were ethnic, wherein the members of the tribe were banded together, initially by kinship and worship of the same gods. Even in the absence of courts and legislature, there was a law, a combination of custom, morality, religion, and magic. The visible authority was the chief. The supreme authorities were believed to be the gods whose will was revealed in the forces of nature and in the revelations of the tribal head or the priest.
Wrongs against the ethnic group, such as sacrilege or breach of tribal custom, were met with group sanctions, including mockery and hostility, and the tribe members taught, with the fury and anger of the gods. The gods were appeased in ritualistic ceremonies, terminating in sacrifice or banishment of the wrongdoer. Injustices against individuals such as murder, theft, adultery, and failure to repay a debt were retaliated by the family of the victim. Often in actions against the family of the wrongdoer, retribution of this kind was based on tribal custom, a major component of early law.
Tribal society progressively evolved into territorial confederations. Governmental organizations emerged as a result. Contemporary law began to take shape. The most considerable historical illustration is Roman law, which influenced most of the legal systems of the world.
In the 8th century BC, the law of Rome was still largely an assortment of custom and interpretation by judges of the bidding of the gods. The magistrates later lost their authority due to blatant discrimination against the lower plebeian class.
The threat of uprising led to one of the most significant developments in the history of law. The 12 Tables of Rome, which were engraved on bronze tablets in 5th century BC. The 12 Tables serves as a historical origin for the widespread modern belief that fairness in law demands that it be in written form. These tables and their Roman successors, together with the Justinian Code, led to civil law codes that provide the main sources of law in much contemporary Europe, South America, and around the civilized world. The common law systems of England and later of the US developed in a dissimilar manner. Prior to the Norman Conquest 1066, England's laws were largely tribal and confined. The Anglo-Norman rulers created a structure of centralized courts that operated under a single set of laws. This legal system began with familiar customs, but over time it involved the courts in lawmaking responsive to changes in societies. There are different types or classifications of law. First is substantive law. What is substantive law? Substantive law defines the rights and duties of a person. And the next is procedural law. Procedural law is a law defines and deals with procedures for enforcing those rights and duties. Substantive law determines a wide assortment of matters. For example, what is required to a form contract? What the difference is between theft and robbery? When one is entitled to compensation for an injury? While the rules of procedure and jurisdiction determine the court or administrative agency that may deal with a claim or dispute, the form of trial, hearing, the time limits involved. Related rules also deal with the kinds of evidence that may be presented. Such rules are more restrictive in trial courts than in administrative agencies. The discerning points of procedural law are considerable, but they are generally thought to be indispensable to whatever competence and fairness law may have. The next is public law. Public law affects and involves the relationships within government and those between governments and individuals. Roman codes were almost entirely limited to the private area. As a consequence, public law is usually not codified. In civil law nation-states, separate administrative courts pass judgment, claims, and disputes between the various branches of government and citizens, and many lawyers specialize in public law. In France, Germany, and Italy, other courts handle constitutional issues. Public law is not quite so clearly defined in Great Britain and the US. Next is the administrative law. The development of administrative law is a comparatively recent episode. Various governmental administrative agencies make rules that reach into all manner of activities, including licensing, regulation of trades and professions, protection of health, and promotion of welfare. Their powers originates from legislation, and their rules are reviewable by the courts. Next is constitutional law. Constitutional law is the most extensive and pervasive of any country in the world. It is embodied in the Constitution and the opinions of the Supreme Court rendered over time. The Supreme Court does more than provide advisory opinions on the Constitution. The power of judicial review allows it to annul any legislation or other governmental actions that it finds to be in violation of the Constitution. Historically, criminal law in Great Britain included crimes defined by the courts. In the US, crimes are defined by the statute, thus satisfying constitutional notions of due process. The public law nature of the area is further emphasized by other constitutional protections such as the right of accused to remain silent and the right to effective counsel. Criminal law not only promotes security and order but also reinforces moral norms. Next is civil or private law. Civil or private law involves the various relationships that people have with one another and the rules that determine their legal rights and duties among themselves. The subject is concerned with rules and principles pertaining to possession, ownership, and use property, contracts between individuals, family relationships, and redress by way of compensation for harm inflicted on one person by another. The next is the international law. The international law is the legal process that concerns relations among nations. Ideas and experience in some form of international law dates from at least the days of the Roman Empire. International law is almost wholly based on custom, and precedents on which it rests are the acts of independent governments in their relations with one another, including treaties and conventions. When treaties or conventions are involved, machinery to enforce them exists, either an arbitration or conciliation procedure or the submission of the dispute to a regional or international court. This concerns such matters as territorial titles and boundaries, use of the high seas, limits on war, telecommunication, diplomatic and consular exchange, and use of airspace. The United Nations is the primary mechanism that enunciate and create international law. And the last one is the criminal or penal law. Criminal or penal law is that division or branch of a public law which defines crime, threats of its nature, and provides further punishment. Signed December 8, 1930, Act No. 3815. The revised penal code is the primary source of the Philippine criminal law. It came into its full implementation on January 1, 1932, and remained in effect today.
Now, let's proceed to principal parts of revised penal code. Articles 1 to 20 is all about principles affecting criminal liability. And Articles 21 to 113 is all about provisions on penalties including criminal and civil liability. And the Articles 114 to 367 is all about the felonies defined under the different titles. So now let's proceed to the sources of criminal law. It has 5 sources of criminal law. These are the Acts, Commonwealth Acts, Batas Pambansa, Presidential Decrees, and the Republic Acts. Acts: 4,275 public acts enacted by the Philippine Assembly from 1901 to 1935. And they are cited as like this. Commonwealth Acts: 733 laws passed from 1935 to 1946, cited as like this. Batas Pambansa: 844 laws passed by the Batasang Pambansa of Philippine Parliament from 1979 to 1985 and cited as like this. Presidential Decrees: 2,034 enactments of the President from the 1972 to 1986 where the Philippines was under martial law, and these are cited as like this. Republic Acts: Congressional enactments from the Declaration of Philippine Independence in 1946 until the declaration of martial law in 1972. And these congressional enactments were assumed in 1987 when the present Congress was organized under the 1987 Constitution. And there are now over 9,000 Republic Acts which are cited as like this.
So now, let's proceed to the characteristic of criminal law. Number 1. It is general in application. The provision of the criminal or penal law must be applied uniformly to all persons within the territory irrespective of nationality, gender, age, and other personal circumstances. And also its certain exceptions includes as heads of state or country, foreign diplomats, ambassadors who are duly accredited to a country, and foreign troops permitted to enarch within a territory. This primarily answer the question who are subject and bound to obey the law.
It is territorial in character, so This answers the query of where the law applies. Territoriality of criminal laws is anchored to the responsibility of the right of a state to self-preservation. So each dependent country has the right to promulgate laws enforceable within its territorial authority subject only to the limitation imposed by treaties of preferential applications and by the operation of international law of nations. So in the Philippines, the revised penal code is applicable only to the areas within the Philippine territorial jurisdiction such as Philippine Archipelago, atmosphere, interior waters, and the maritime zone. So in Philippine Archipelago, this includes all the islands that comprise the Philippines. So in the atmosphere, here it includes exclusive Philippine airspace. Interior waters, all bodies of water that connects all the islands such as bay, rivers, and streams. And in the maritime zone, the 3-mile limit beyond our shore measured at low tide. So, the exemptions to the territorial character of the criminal law according to the Article 2 Revised Penal Code shall be applicable to all cases committed outside the Philippine territorial jurisdiction under the following circumstances. And these are, should commit an offense while on a Philippine ship or airship. And next, should forge or counterfeit any coin of currency note of the Philippine island or obligations and securities issued by the government of the Philippine island. Should be liable for acts connected with the introduction into these islands of the obligation and securities mentioned in the preceding number. Next, while being public officers or employees, should commit an offense in the exercise of their function. Next, should commit any of the crimes against national security and law of nations defined in Title 1 of Book 2 of this Code, Revised Penal Code. So on the other hand, even if the crimes of felonies are committed within the Philippine territory, the Revised Penal Code is not applicable under the following circumstances or situations. So here, provisions of treaties signed by the Philippines and other countries, and operation of international law under the principle of reciprocity. There are two types of rule under the criminal law, and these are French rule and the English rule. General rule of French rule: crimes committed aboard a foreign merchant vessel are not triable in the country where they were committed. So in the English rule, the general rule of it is crimes are triable in the country where they were committed. So the exception of French rule, when the commission of said crimes affect the peace and security of the territory where they were committed. In the English rule, the exception of it is they merely affect things within the vessel or they pertain to the internal management thereof. So in our jurisdiction, we follow the English rule.
The next is, it is specific and definite. The criminal law must give a strict definition of a specific act which constitute an offense. Where there is a doubt as to whether a definition embodies in the revised penal code applies to the accused or not, the judge is obligated to decide the case in favor of the accused. Criminal law must be construed liberally in favor of the accused and strictly against the state. Number 4, it is uniform in application. An act describe a crime is a crime no matter who committed it, wherever committed in the Philippines and whenever committed. No exception must be made as to criminal liability. The definition of crimes together with the corresponding punishment must be uniformly construed, although there may be differential enforcement of a given specific provision of the penal law.
Next is, it must be prospective. This answers the question when are laws applied. According to Article 22 Revised Penal Code, no person can be punished for his act which, at the time he did it, is not yet punishable by law. However, penal laws may be given retroactive effect when it is favorable to the accused who is not habitual delinquent. To give a law a retroactive effect or application to the prejudice of the accused is to make it an ex post facto law. An ex post facto law is a law which makes a criminal act
done before the passage of the law and which was innocent when done and punishes said act. A bill of attainder, on the other hand, is an act of Congress which inflicts punishment without trial. Such a legislative act is prohibited under the Philippine legal system. Next is, there must be a penal sanction or punishment. So, the penal sanction is the most essential part of the definition of the crime. If there is no penalty to a prohibited act, its enforcement will almost be impossible. The penalty is acting as deterrence, retribution, and as a measure of self-defense of the state to protect society from the threat and wrong inflicted by the criminal. Let's proceed to the constitutional restrictions on penalties. The 1987 Freedom Constitution directs that excessive fines shall not be imposed, nor cruel and unusual punishment inflicted. The punishment or penalty imposed is deemed unusual and cruel when it is disproportionate to the offense committed and morally choking to a person of reasonable mind as to what is commensurate under the circumstances which attended its commission. So, there are 6 penalties as a juridical rule must conform to the following standards. The first is, it must be productive of suffering without affecting the integrity of the human personality. Second, it must be commensurate of the offense, hence different crimes are punished with different degrees of penalty. Third, it must be personal. This requires that the offender would have to suffer for his transgressions to the law and not be imposed on others. Fourth, it must be legal. This means that due process must be observed before the imposition of punishments. The fifth, it must be equal for all. This borders on facts that the state would have to apply the laws without bias and favor, and its imposition is general. And the last one, it must be correctional. It must be able to redeem and uplift valuable human material and prevent unnecessary deprivation of liberty and economic usefulness.
Jurisprudence was from a Latin word jurisprudentia. Jus means law and prudentia means knowledge. It refers to the knowledge of the law and its interpretation, or the science and philosophy of law. In primeval Rome, the term was used in the former sense. Those who were so skilled in the law that they could decide a unique or doubtful case were called jurisprudentes, whether or not they were judges, and the body of law built up by their interpretation was called jurisprudentia. This development of law by interpretation is similar to what English-speaking peoples call case law. Law arising from a body of decided cases, and in France and Spain, the term jurisprudence is still used in that sense.
The word jurisprudence is usually used to explain and illustrate what was often called, at an earlier period, the philosophy of law, and what continental writers now call the theory or science of law. An English or U.S. treatise on jurisprudence defines the essential elements in our conception of law. So the relation that law bears to the cognate social sciences, politics, ethics, and economics, the way in which law originates in popular customs, judicial usage, and legislation. Also the way in which it ceases to exist by desuetude, change of usage, abrogation, or repeal, and its application with reference to persons, time, and place, and the way in which it is enforced.
Jurisprudence articulates and frames legal relations, rights, and duties. It may undertake to categorize law and to construct a system in which every rule of law may find an appropriate place. Also, it may attempt to classify all the relations that the law recognizes or give rise to and which it regulates or orders, that is, the relations of state and government to individual and groups, and of individuals and groups to each other. It may even examine and investigate the fundamental conceptions of the family, of property, and of succession.
So now let's proceed to the schools of jurisprudence. The major modern schools of jurisprudence are the natural law school, the analytical school, the historical school, the comparative school, and the sociological school. The first three schools, which is the natural law school, the analytical school, and the historical school, disagree mainly in their views of the nature and origin of law and its relation to ethics. To the natural law jurists, law is precursor to the state. To the analytical jurists, it is the foundation of the state. And to the historical jurists, state and law are social products developing side by side, each have an effect on the other. And also, to the natural law jurists, law is cognizable by pure logic and wisdom. To the analytical jurists, it is the authority and domination of the sovereign power. And to the historical jurists, it is the formulated wisdom of men and women, which is a consequence of legislation.
In the relation to ethics, the natural law jurists, law is practical and applied ethics, and in the radical form of the theory, that which is not right is not a law. To the analytical jurists, a law that commands what is ethically wrong or forbids what is ethically right is no less a law if it progresses from the political sovereign. The historical jurist recognizes this position taken by the analytical school, but points out that it is easier said than for a lawmaker to act otherwise than in accord with the contemporary sense of right, and that laws which run contradictory to that sense are not likely to be enforced.
So now let's proceed to the origin of the natural law school. The natural law school has its origins and roots in Stoic philosophy and Roman jurisprudence. It was increasingly prevailing in Europe from the Reformation to the close of the 18th century. The philosophy of the analytical school was first sharply formulated by the English theorist Thomas Hobbes in his Leviathan 1651. So this objective could be attained only by national legislation and has been fully attained only by the adoption of national codes. So next will be the origin of the historical school dates from the 19th century as a response against natural law ideas. Its principles were first plainly defined in 1814 by the German jurist Friedrich Karl von Savigny. The most recent school, the comparative, of which the leading early exponents were the German legal scholar Rudolf von Jhering and the Albert Hermann Post, represents a widening of the field of investigation. Each national law is studied in times gone by, and the various national systems are compared at similar stages of development. Then, as Jhering hoped, it may in due course become possible to write a history of the law of the world. Among the principal British and American writers on comparative law were James Barr Ames, Oliver Wendell Holmes, Henry Maine, Frederick William Maitland, and Sir Frederick Pollock. The sociological school of jurisprudence is mainly a product of the 20th century. Its methodology to the analysis of law are at odds from that of the other schools in that it is concerned less with the nature and origin of law than with its actual functions and end results. They are concerned with sensible and practical improvement of the legal system and feel that this can be achieved only if legislation and court adjudications take into account the findings of other branches of learning, principally the social sciences. The American jurist Roscoe Pound was a leading figure in the School of Sociological Jurisprudence.
So now, let's proceed to the two important theories in criminal law. So what are they? The classical theory and the positive theory. So now, we will discuss the first important theory in criminal law, and which is called the classical theory. The classical theory has characteristics, and these are the characteristics. The basis of criminal liability is human free will, and the rationale of the penalty is retribution. and also when that man is essentially a moral creature with an absolute free will to decide between good and evil, thereby placing more emphasis upon the effect or result of the felonious act than upon the man, the criminal himself. Also, it has endeavored to create a mechanical and direct proportion between crime and penalty. And the last characteristic is, there is a negligible or little regard to the human element. So now, let's proceed to the second theory of criminal law, which is the positive theory. Positive theory, it also has characteristics. And these are the characteristics. When that man is occasionally subservient to strange and morbid phenomenon which constrains him to do wrong, even though contrary to his violation. And also, when that crime is basically a social and natural phenomenon, and as such, it cannot be prevented and treated by the application of abstract principles of law and jurisprudence, nor by the imposition of punishment, fixed and determined adequate, but rather by means of the enforcement of individual measures in each particular case after a meticulous, personal and individual investigation performed by a competent body of psychiatrists and social scientists.
And lastly, the theories as to the origin of criminal law was that criminal law originated from private wrong of tort, and also that criminal law originated from the national processes of a unified society, and also that criminal law originated from the development of custom, usage, and tradition. And lastly, that criminal law originated from conflict of interests of different social groups. So that will end our video presentation about the Chapter 2, Essentials of Criminal Law.
That's all, folks. If you want the answers, just make your comments, like, share, and subscribe. Thanks for watching. See ya!